For now, I want to focus on the form and the substance of the transaction, and I want to analyze the Vodafone case. Okay, so the Vodafone case has been in the news for all the, well, wrong reasons. If you're an investor, right, basically, you don't want what happened to Vodafone to happen to you. Okay, so what exactly happened to Vodafone? Okay, Vodafone was a case of ingenious tax avoidance. Okay, now let's go to the facts of the case. What happened, right? And I quote from the case itself, from the judgment of S.H. Kapadia, right? Excellent judgment, which Swatantra Kumar concurred with. Okay, well worth a read. So, and I quote, this matter, Vodafone, yeah, concerns a tax dispute involving the Vodafone Group with the Indian tax authorities, hereinafter referred to for short as the revenue, in relation to the acquisition by Vodafone International Holdings BV, for short VIH, of a company, right, basically in the Cayman Islands. Okay, so what happened? You have the Vodafone Group, which is in a dispute with income tax authorities. Yeah, you have the Vodafone Group, which is in dispute with the income tax authorities. Now, Vodafone International Holdings, VIH, yeah, is a company that is resident for tax purposes in the Netherlands. Yeah, and what does this company, VIH, resident in the Netherlands, do? They acquire the entire share capital of CGP Investment Holdings, okay, a company resident for tax purposes in the Cayman Islands, whose stated aim, yeah, the stated aim of the transaction, according to the revenue, was acquisition of 67% controlling interest in Hutchinson Essar Limited, HEL for short, being a company resident for tax purposes in India. So you have the Vodafone, yeah, you have the Vodafone International Holding Groups, the VIH in Netherlands, you have the CGP in the Cayman Islands, you have the VIH acquiring CGP, and the VIH, by acquiring CGP, in turn acquires a 67% interest in Hutch, which is a company resident for tax purposes in India. Okay, so two companies transact to acquire an asset in India. Two companies transact to acquire an asset in India. Okay, now, all right, the revenue. Why did they bring a case against Vodafone? The revenue, yeah, seeks to tax or sought to tax capital gains arising from the sale of the share capital of CGP, the company in the Cayman Islands, on the basis that CGP, yeah, whilst not a tax resident in India, held the underlying Indian assets. They held the underlying Indian assets, basically. They owned a majority stake in Hutchinson Essar Limited. Now, right, let's get back to basics. Okay, what we have here is an embodiment of the separate entity principle. Yeah, the Indian Income Tax Act 1961, in the matter of corporate taxation, is founded on the principle of the independence of companies and other entities subject to income tax. Companies and other entities are viewed as economic entities with legal independence. Yeah, vis-a-vis shareholders and participants. Fairly well accepted that a subsidiary and its parent are totally distinct taxpayers. So a subsidiary and its parent company are distinct taxpayers. We know that. Okay, so now, right, if an actual controlling non-resident enterprise makes an indirect transfer through abuse of organization form, right, and without reasonable business purpose, which results in tax avoidance or avoidance of withholding tax, then the revenue may disregard the form of the arrangement or the impugned action through use of a non-resident holding company, recharacterize the equity transfer according to its economic substance, and impose the tax on the actual controlling NRE. So that's exactly what the revenue sought to do, right? You have Vodafone International Holdings, Netherlands, CGP Cayman Islands, Hutchinson Essar Limited, which is acquired essentially by Vodafone. How does Vodafone acquire Hutch? What does Vodafone do? They buy CGP, which controls Hutch, basically. So the underlying assets of the transaction are in India, basically. Vodafone, they knew if they acquired Hutch, Vodafone knew if they directly acquired Hutch, basically in India, right, a company which is resident in India for tax purposes, they'd be looking at a pretty hefty tax bill. Yeah, they'd be looking at a pretty hefty tax bill. Okay, so what do they do instead? They use the Cayman Islands company to buy Hutchinson Essar Limited, basically to acquire the assets there. The question is, right, was it an act by the non-resident enterprise VIH, Vodafone International Holdings, through an abuse of organization form without reasonable business purpose? Was there a reasonable business purpose for Vodafone to acquire Hutch through CGP. Was there a reasonable business purpose? Okay, now, and I quote again from the judgment. When it comes to taxation of a holding structure, at the threshold, the burden is on the revenue to allege and establish abuse in the sense of tax avoidance, in the creation and or use of such structures. In the application of a judicial anti-avoidance rule, the revenue may invoke the substance over form principle of piercing the corporate veil test only after it's able to establish on the basis of the facts and circumstances surrounding the transaction that the impugned transaction is a sham or tax avoidant. Is it a sham transaction? Absolutely not. Look at Vodafone today. Look at the commercial presence they have in our country, right? It was that single acquisition of Hutchinson Essar that propelled Vodafone into the Indian market, right? That transaction had a very viable and legitimate business purpose. Yes, the organization form, yes, was manipulated in a manner whereby Vodafone did not have to pay tax in India, but that is fine. That is exactly why we have the separate entity principle. Why do you create a company? You create a company because as a sole proprietor, right, or in a partnership, you are far too exposed. So instead, you create a company whereby you insulate yourself. You are one of the promoters of the company. You have other directors, you have shareholders, but it is the company that has the legal existence. Here, Vodafone International Holdings acquired CGP for a reasonable business purpose. There was a commercial purpose, right? It was not a tax avoidant transaction. The purpose of the transaction was not tax avoidance. The purpose of the transaction was to acquire a presence in the Indian telecom space, was to acquire a presence in the Indian telecom market. And today we see that Vodafone is everywhere, right? Basically, that is why they acquired Hutchinson Essar. The fact that they used organization form to essentially avoid taxes is permissible as long as the transaction is not a sham or simply based on tax avoidance. Okay, so the court said, in a case where the revenue finds that in a holding structure, an entity which has no commercial or business substance has been interposed only to avoid tax, then in such cases, right, applying the test of fiscal nullity, it would be open to the revenue to discard such interpositioning of that entity. Okay, fair enough. If the creation of that entity has simply been to acquire Hutchinson Essar, yeah, the revenue has the power to discard that interpositioning of CGP. Okay, so what is the principle to be applied to see that, has Vodafone simply created a company to acquire Hutch? Has Vodafone simply created a company in the Cayman Islands to acquire Hutch? That actually did not happen. Okay, in the case, right, CGP had existed for a while, but we'll come to that. Okay, the principle to be applied is the look at principle. The look at, in quotes, principle. In this connection, the Supreme Court said, we may reiterate the look at principle. The revenue or the court must look at a document or a transaction in a context to which it properly belongs to. It is the task of the revenue or the court to ascertain the legal nature of the transaction, and while doing so, it has to look at the entire transaction as a whole and not to adopt a dissecting approach. That's exactly what our revenue did. They said, oh, look at this. Look at this small aspect, not a small aspect, but look at this aspect of it. Look at this aspect of the transaction. Okay, they didn't look at the history of, the acquisition by Vodafone International Holdings, and they did not look at their business strategy of entering the telecom market. They just looked at this part of the transaction. Right, the revenue just looked at this part of the transaction and they said, oh, what's Vodafone doing? Oh, Vodafone is just using CGP to acquire Hutchinson Essar, basically. And that's a tax avoidance transaction, and that's not permissible. The revenue cannot start with the question as to whether the impugned transaction is a tax deferment saving device, but that it should apply the look at test to ascertain its true nature. What did the Supreme Court say? They said, please look at the entire transaction first. Please don't look at it from the point of view of, oh, is this a tax avoidant transaction? First, you ascertain the legal nature of the transaction, and once you ascertain the legal nature of the transaction, it will logically follow, you will have your answer as to whether it's a tax avoidant sham transaction or not. The Supreme Court said the revenue, while doing so, should keep in mind the following factors: the concept of participation in investment, the duration of time during which the holding structure exists, the period of business operations in India, the generation of taxable revenues in India. The generation of taxable revenues in India. Do you know that Vodafone, right, between 2003 or 4 and 12 had generated 20,000 crores? Yeah, 2004 and 2012, 20,000 crores to the Indian exchequer, basically, right? So you have to look at the generation of taxable revenues in India. If you allow Vodafone to acquire Hutch, what happens? It means more tax for us. Like today, Vodafone is dabbling in 2G, 3G, 4G. Vodafone is everywhere. Basically, that's more tax, okay? The timing of the exit, the continuity of business on such exit, these are all factors to be looked at, basically. So, what does the Supreme Court say? In short, the onus will be on the revenue to identify the scheme and the dominant purpose of the transaction. Now, there's another issue here, okay, which we need to consider, which is Section 9. What is happening here? What is the revenue trying to do? Essentially, they are trying to tax Vodafone, okay? They are trying to tax Vodafone and they're trying to get capital gains out of them, okay? Yeah, because the assets are in India and they argued basically, they argued that it was an acquisition of underlying assets. It was an acquisition of underlying assets in India, basically, okay? Supreme Court rejected that argument, okay? They rejected that argument. They said, look, right, once the factum of a transfer is established by the department, income accruing or arising to a non-resident outside India on transfer of a capital asset situated in India is fictionally deemed to accrue or arise in India, which income is made liable to be taxed by reason of Section 5 of the Act. This is the main purpose behind the enactment of Section 9, right? What is the main purpose of Section 9? If the income essentially, right, arises, yeah, if the income arises as a result of a business arrangement, yeah, in India, basically, fictionally that income is deemed to accrue or arise in India, okay? The purpose is basically you want to tax that. So the question is essentially, right, has income deemed to accrue or arise in India by virtue of the transfer of a capital asset situated in India, basically, okay? Now, let's look at the judgment of the case. I hope you're with me. Just please read the slides and you'll follow everything I'm saying, okay? Judgment, okay, and I quote, applying the look-at test in order to ascertain the true nature and character of the transaction, we hold that the offshore transaction here is a bona fide structured FDI investment into India which fell outside India's territorial tax jurisdiction and hence not taxable. The said offshore transaction evidences participative investment and not a sham or tax avoidant preordained transaction. The said offshore transaction was between a Cayman Islands company and a company incorporated in Netherlands. The subject matter of the transaction was the transfer of the CGP, company incorporated in Cayman Islands. Consequently, the Indian Tax Authority had no territorial tax jurisdiction to tax the said offshore transaction. Vodafone won. Okay, they said applying the look-at principle, looking at the transaction in the whole, taking into various factors, yeah, various factors such as the holding structure, right, the concept of participation in investment, generation of taxable revenues in India, etc. They held that this was a genuine FDI investment in India, right? It was a transaction between two non-resident companies, right? It was a clear transaction between two non-resident companies. There was no income which deemed to accrue or arise in India. Okay, there is no such thing as underlying assets. There was no such thing back then. Yeah, the concept of underlying assets, right? You cannot simply assume something like that, was what the Supreme Court said. This is not a tax avoidant or sham transaction. It is a transaction which has a genuine, viable commercial purpose, basically, and Vodafone won the case. The impact of Vodafone, well, Pranab Mukherjee, the then finance minister, amended it and amended Section 9 to add underlying assets to it. Explanation 5 was amended and clarified that an asset or capital asset, being any share or interest in a company or entity registered or incorporated outside India, shall be deemed to be situated in India if the share or interest derives directly or indirectly its value substantially from the assets located in India. Draconian provision, lack of clarity, there was retrospective operation. Okay, now Narendra Modi and his government have clearly said, right, that his government will not invoke any tax law retrospectively, right, and they've also said that they will not resort to retrospective taxation and will not appeal the Vodafone decision. Okay, so Vodafone essentially has won, and the Indian government has given an assurance that they will not appeal this decision, basically. Okay, thereby, right, making a giant stride, taking a giant step towards a stable and predictable tax regime in India.